If you're a green card holder, I want you to slow down for a moment and really listen, because what I'm about to explain is not theory, it's not exaggeration, and it's not something that only happens to other people. These are real situations that happen every single day to people who honestly believe they were safe. Most green card holders walk around with a sense of quiet confidence. They waited years. They filled out forms. They passed background checks. They paid lawyers. They finally received that card and told themselves, I made it. And for a long time, nothing bad happens. Life goes on: work, family, bills, travel, routines. That sense of security becomes automatic. But what very few people understand is that a green card is not permanent in the way most people think it is. It is permanent only if your actions, patterns, and decisions continue to align with what U.S. immigration law expects from a permanent resident. The moment those expectations are violated, even unintentionally, the protection you think you have can start to weaken. And the most dangerous part is that this process is usually silent at first. There is no warning alarm, no phone call, no letter saying you are in danger. Instead, it starts with patterns, travel patterns, filing patterns, behavioral patterns. And once those patterns exist, they can be used against you years later. This is not about fear. This is about awareness. If something goes wrong with your status, it rarely affects only you. If your spouse or your children receive their green cards through you, their status becomes tied to yours. One problem can place an entire family into removal proceedings. Children who have grown up in the United States, who speak English better than their parents' native language, can suddenly face the possibility of leaving the only home they know. This is why understanding how green cards are lost is just as important as understanding how they are obtained. One of the most common starting points for trouble is travel. Permanent residents are allowed to travel outside the United States. That much is clear. You can visit family, attend funerals or weddings, manage property abroad, take extended vacations, or accept short-term work assignments. Travel itself is not illegal. Travel itself does not violate your status. What creates problems is how immigration authorities interpret your travel over time. Many green card holders believe in a very simple rule. They believe that if they never stay outside the United States for more than 6 months, they are completely safe. That belief is widespread, and it is dangerously incomplete. If every single trip you take is under 6 months, you are generally in a safer category. But even then, safety is not guaranteed. The moment one trip goes beyond 6 months, even by a few days, your legal position changes. When you return after a long trip, Customs and Border Protection officers are not just stamping your passport. They are evaluating intent. They are evaluating whether you still see the United States as your permanent home. They can ask you why you were gone for so long. They can ask where you live. They can ask where you work. They can ask whether you are working abroad. They can ask whether you still maintain a residence in the U.S. They can ask about your family. They can even ask about past arrests or criminal history that may have never been an issue before. Once you have been outside the U.S. for more than 180 days, officers are legally allowed to subject you to this kind of questioning. And while many people are allowed back in without incident, others are not so lucky. If your absence exceeds 12 months, the risk increases significantly. Without a re-entry permit, USCIS may treat your absence as abandonment of permanent residency. That means they can argue that by staying away for so long, you chose to live elsewhere. At that point, the burden often shifts to you to prove that you never intended to abandon your status. And proving intent after the fact is extremely difficult. What many people fail to understand is that immigration law does not look only at individual trips. It looks at patterns. You could technically comply with the 6-month guideline on every trip and still face problems if your overall pattern shows that you spend more time outside the United States than inside it. If over several years your record shows that you are present in the U.S. for only short periods and absent for long stretches, officers can argue that the United States is no longer your primary home. Intent matters, but behavior is often used to infer intent. This issue has become even more serious in recent years because of how advanced travel tracking has become. Every entry and exit is logged electronically. Your photo is captured. Your travel history is stored. Patterns are analyzed automatically. Officers no longer need to rely on memory or guesswork. The data is there. If you want to reduce your risk, the safest approach is to spend the majority of each year physically inside the United States. Many attorneys recommend at least 9 to 10 months per year. And if there is any chance you will be outside the U.S. for 6 months or more, applying for a re-entry permit before leaving is one of the most important protective steps you can take. A re-entry permit does not guarantee admission, but it signals that you did not intend to abandon your residency, and it can make a significant difference when your case is reviewed. Another major area where people get into trouble is the lack of strong ties to the United States. Many green card holders believe that travel alone determines their status. In reality, USCIS evaluates where your life is anchored. They look at your residence. Do you maintain a real consistent address in the U.S.? Do you have a lease, a mortgage, or a long-term living arrangement with family? Or do you appear to be floating between countries? They look at your finances. Do you maintain active U.S. bank accounts? Do you use them regularly? Do you have U.S. credit cards? Do you file taxes every year as a resident? They look at employment. Are you employed by a U.S.-based company? Do you run a business here? Or does your income primarily come from abroad? They look at family. Does your spouse live in the U.S.? Do your children live here? Are your children enrolled in U.S. schools? They look at community connections, driver's licenses, professional memberships, religious involvement, and other social ties all help demonstrate that your life is rooted in the United States. When too many of these ties are missing, USCIS can argue that you have effectively shifted your life elsewhere. And once that argument is made, defending against it becomes much harder. Criminal issues represent another major risk area, and this is where many people are caught completely off guard. USCIS is not concerned with minor traffic violations like parking tickets, but crimes involving fraud, theft, drugs, or physical harm are treated very seriously, even if criminal court considered them minor. Immigration law categorizes certain offenses as crimes involving moral turpitude. These include offenses that suggest intent to deceive or harm, such as theft, fraud, domestic violence, or assault. If one of these crimes occurs within the first 5 years of permanent residency and carries a possible sentence of 1 year or more, you can become deportable. What matters is not the sentence you actually received, but the maximum possible sentence under the law. This surprises many people. Someone may receive probation or no jail time at all and assume the matter is closed only to discover later that immigration authorities view the offense very differently. Having 2 or more such crimes at any time, even if they occurred years apart, can also trigger removal proceedings. And aggravated felonies are even more serious. Violent crimes, sexual offenses, and drug trafficking offenses almost always lead to mandatory detention and deportation, with very limited defenses available. Even offenses like DUI carry more risk than many people realize. A single DUI can delay citizenship. Multiple DUIs can lead to denial. Lawmakers have openly discussed making even one DUI a deportable offense for non-citizens, which shows how aggressively these issues are being examined. Another critical point that many people do not understand is that immigration law does not always require a conviction. Guilty plea, no contest plea, probation, diversion programs, and even some expuned cases can still count as convictions for immigration purposes. This means that agreeing to a plea deal without understanding immigration consequences can permanently damage your status. Many criminal defense attorneys focus on reducing jail time or fines, and do not fully understand immigration law. 1. Wrong decision can place you into removal proceedings. Taxes are another silent risk that builds over time. As a green card holder, you are required to file a tax return every year and report worldwide income. This applies even if you earned money abroad or lived outside the United States for part of the year. Skipping tax years, filing incorrectly, or claiming non-resident status can be used as evidence that you do not consider the United States your permanent home. Large unpaid tax balances, ignored IRS notices, or patterns of non-compliance can delay citizenship and trigger USCIS scrutiny. In serious cases, tax evasion can even be classified as an aggravated felony. USCIS is not looking for perfection. They are looking for responsibility. Filing your returns, correcting mistakes, setting up payment plans if necessary, and keeping proper records can significantly reduce your risk. One of the fastest and most unforgiving ways to lose a green card is by making a false claim to U.S. citizenship. This can happen more easily than people think. Checking the wrong box on a form, registering to vote, voting in an election, applying for benefits as a citizen, or using someone else's documents can all count. In many cases, intent does not matter. Even unintentional claims can result in permanent loss of status and removal proceedings. There are very few exceptions, and almost no way to fix the problem once it occurs. Conditional green card holders face another serious risk. A 2-year green card cannot be renewed. You must file Form I-751 during the 90-day window before it expires. Filing late can automatically place you out of status and trigger removal proceedings. Waivers exist for certain situations such as divorce, death of a spouse, abuse, or extraordinary circumstances. But doing nothing is the worst option. Letting the card expire without action can have severe consequences. Marriage-related issues are also heavily scrutinized. USCIS treats marriage fraud extremely seriously. Even real marriages can raise concerns if documents are inconsistent, living arrangements are unclear, or one spouse refuses to cooperate. USCIS can revoke even a 10-year green card later if they determine that the marriage was not genuine at the time of approval. Misrepresentation is another hidden danger. This includes providing false or misleading information on any immigration form, hiding past immigration issues, or submitting inconsistent details across applications. DHS now uses advanced systems to cross-check information from multiple sources. Honest mistakes do not automatically lead to problems. The issue arises when USCIS believes the false information was intentional and affected the outcome of your case. Failing to update your address is a surprisingly common mistake. Green card holders are legally required to notify USCIS within 10 days of moving. Filing with the post office does not update USCIS records. Missing this step can lead to missed notices, denied applications, or enforcement actions. Finally, some people lose their green cards by voluntarily abandoning them. Signing Form I-407 permanently ends your residency. There is no appeal and no automatic way to reverse this decision. It also affects family members who received their status through you. Once you give up your green card, you become a foreign national again and may need a visa just to visit the United States. Getting permanent residency again usually means starting the entire process from the beginning. When people hear all of this for the first time, they often assume that immigration enforcement works in a dramatic way. They imagine agents knocking on doors, sudden arrests, or immediate deportation. In reality, most green card problems begin quietly, often during routine interactions that seem harmless at the time. A very common example is applying for something else. You apply to renew your green card. You apply for naturalization. You apply for a re-entry permit. You apply to sponsor a family member. And during that process, USCIS begins reviewing your entire history, not just the form you submitted. Travel records, tax filings, criminal records, prior immigration filings, everything is examined together. This is why people are often shocked when an application they expected to be routine suddenly turns into a denial or a notice to appear in immigration court. They think, I applied for citizenship. How did this turn into a deportation case? But from USCIS's perspective, the application simply gave them an opportunity to look more closely. Another issue that causes serious problems is misunderstanding how immigration law treats intent. Many green card holders believe that as long as they did not mean to violate the law, they are protected. Unfortunately, immigration law does not always work that way. Intent matters in some situations, but behavior and evidence often matter more. If your actions consistently point in a certain direction, USCIS may draw conclusions regardless of what you say later. This is especially true in cases involving abandonment, misrepresentation, and false claims. For example, someone may genuinely believe they never intended to abandon their green card. But if the evidence shows they lived abroad for long periods, worked overseas, failed to maintain a U.S. residence, and filed taxes incorrectly, USCIS may conclude otherwise. At that point, explaining your intentions becomes very difficult. Another area where people get confused is the role of discretion. Immigration officers have discretion in many situations, but discretion is not unlimited. When certain legal thresholds are met, officers may have no choice but to take enforcement action, even if the individual appears sympathetic. This is especially true in cases involving criminal convictions, false claims to citizenship, and aggravated felonies. Once the legal definition is met, there may be very little room for mercy or flexibility. This is why early decisions matter so much. The choices you make today may not affect you immediately, but they can shape how your case looks years later. A travel decision, a tax decision, a plea agreement, a form filled out too quickly. All of these can resurface. Another issue that often surprises people is how dependent family members are affected. Many green card holders assume that if something happens to them, their spouse or children will be treated separately. In reality, derivative status is often tied to the principal applicant. If your spouse or children receive their green cards through you and your status is taken away, their status may also be revoked. This can place entire families into removal proceedings together. Children who have lived in the United States for most of their lives may suddenly be facing a future they never expected. This is why immigration law must be approached with a long-term mindset. It is not just about staying out of trouble today. It is about preserving your options for the future. Another point that deserves attention is how technology has changed immigration enforcement. In the past, inconsistencies might go unnoticed. Today, data systems are far more advanced. Information from different agencies is shared and cross-referenced. Travel records are matched with tax filings. Employment records are compared with visa histories. Prior applications are reviewed side by side. Even small inconsistencies can raise questions when viewed in combination. This does not mean that every mistake will lead to consequences. Honest errors still happen, but it does mean that patterns of inconsistency are much harder to ignore. For example, someone might list one address on a tax return, another on an immigration application, and a third on a driver's license. Each individual entry may seem insignificant, but together they can raise questions about credibility and intent. This is why consistency matters so much. Before submitting any application, it is important to review your past filings and ensure that the information aligns as closely as possible. If there are discrepancies, they should be addressed carefully and correctly. Another area that causes unexpected trouble is employment. Some green card holders assume that once they have permanent residency, employment rules no longer matter. While it is true that green card holders have broad employment authorization, certain activities can still raise concerns. Working primarily outside the United States, being employed by a foreign company for long periods, or structuring work in a way that suggests your primary economic life is abroad can all contribute to abandonment arguments. Similarly, claiming certain tax benefits or exemptions intended for non-residents can be used as evidence that you do not consider yourself a permanent U.S. resident. These issues often arise during citizenship applications. Naturalization requires showing continuous residence and physical presence. When USCIS evaluates these requirements, they often uncover issues that were never addressed earlier. Another point people underestimate is the emotional toll of immigration proceedings. Removal cases are not just legal battles. They affect mental health, finances, careers, and family stability. People may be required to attend multiple court hearings over several years. Work authorization may become uncertain. Travel becomes risky or impossible. This is why prevention is always easier than defense. Once a case reaches immigration court, options are limited, timelines are long, and outcomes are uncertain. Another common misconception is that long-term residence alone guarantees safety. People who have lived in the U.S. for decades often believe they are untouchable. While length of residence can be a positive factor in some cases, it does not erase legal violations. Even people who have lived in the U.S. for 20 or 30 years can face removal if certain legal thresholds are met. Time does not cure everything. This is particularly important for people who delay citizenship applications. Many assume they can apply someday and put it off indefinitely. But waiting too long can increase risk, especially if enforcement priorities or laws change. At the same time, applying for citizenship without addressing underlying issues can also be dangerous. This is why timing and preparation matters so much. Another factor that complicates matters is misinformation. Many green card holders rely on advice from friends, family members, or online forums. While these sources may be well-intentioned, immigration law is highly fact-specific. What worked for one person may be disastrous for another. Statements like, "I did the same thing and nothing happened," are extremely dangerous. Enforcement is inconsistent, and outcomes depend on timing, evidence, and discretion. The absence of consequences in one case does not mean safety in another. This is especially true in areas like travel, taxes, and criminal issues. Someone may travel frequently and never be questioned, while another person with a similar pattern is stopped and placed into proceedings. Someone may miss tax filings and face no immediate consequences, while another person's case is flagged. Immigration law does not operate on fairness in the way people expect. It operates on statutes, regulations, and enforcement priorities. This is why understanding risk, rather than relying on luck, is so important. Another issue that deserves attention is how changes in administration affect enforcement. Policies shift, priorities change. What was overlooked in one period may be aggressively enforced in another. This does not mean panic is necessary. It means awareness and preparation are essential. Many green card holders only start paying attention to these issues when they plan to apply for citizenship. By then, some problems may already exist. Travel history cannot be changed. Tax filings cannot always be undone. Criminal records cannot be erased for immigration purposes. This is why it is important to think ahead. Even if you do not plan to apply for citizenship soon, your actions today shape your options later. Another area people rarely think about is how immigration views statements made to other government agencies. Statements made to the IRS, state agencies, or even employers can be compared with immigration filings. Inconsistent claims about residence, employment, or status can raise credibility issues. For example, claiming non-resident status for tax purposes while maintaining a green card can be used as evidence of abandonment. Similarly, listing a foreign address on multiple official documents can raise questions. Again, none of these issues automatically result in loss of status, but when combined, they can create a narrative that is difficult to overcome. This is why careful planning matters. Before making major decisions about travel, employment, or residence, it is wise to consider how those decisions will appear on paper. Another point worth discussing is the emotional tendency to minimize risk. People often tell themselves, "It won't happen to me," or "I'll deal with it later." This is human nature, but immigration law is not forgiving of procrastination. Deadlines matter. Filing windows matter. Address updates matter. Missing a deadline by even one day can have serious consequences. This is especially true for conditional green card holders. The I-751 filing window is strict. Missing it without qualifying for a waiver can result in automatic loss of status. Similarly, failing to respond to USCIS notices can lead to denials or abandonment findings. Notices are often time-sensitive. Missing one because of an address issue or inattention can be costly. Another subtle issue involves how immigration authorities view cooperation. Failure to comply with requests for evidence, interviews, or documentation can be interpreted negatively. Even if the underlying case is strong, lack of responsiveness can damage credibility. This is why maintaining organized records is important. Travel records, tax transcripts, employment documents, and prior filings should be kept and easily accessible. As this discussion continues, one theme becomes clear. Most green card losses are not caused by one dramatic act. They are caused by accumulation, small decisions, repeated patterns, missed details. Understanding this allows you to shift from reactive thinking to proactive thinking. Instead of asking what happens if something goes wrong, you start asking, how do I reduce risk before problems arise? That mindset alone can make a significant difference. And this brings us to another important reality. Immigration law is not static. It evolves. Court decisions change interpretations. New regulations are introduced. Enforcement priorities shift. What is acceptable today may be scrutinized tomorrow. This does not mean that everyone should live in fear. It means that green card holders should remain informed and cautious, especially when making decisions that affect long-term status. The most important takeaway so far is this: permanent residency comes with responsibilities. It is not just a benefit. It is a legal status that must be maintained through consistent behavior. Understanding these responsibilities allows you to protect not only yourself, but also your family and your future options.